Hi, everybody. My name's Attorney Thomas Stanton. I am the managing shareholder of Stanton IP law firm. And today I wanted to talk to you about IP ownership and making sure that you have proper agreements in place to avoid long, expensive complications and what kind of scenarios can evolve from that. All too often, creators, inventors, co-founders get together, they get very excited and happy. They create something that's pretty cool, and sometimes it can become very valuable. And they oftentimes skip over the most important part of that, which is who actually owns it. Is it you as an individual? Is it the company? Is it a combination of the two? Is there licensing involved? Is it a direct ownership? Is there some that was created before a company was created that's owned by an individual? And then is there additional add-ons or improvements that are owned by the company? The general rule of thumb is that if you are an employee of a company and you create something for that company, then the company typically owns it, even if it's not explicitly written out. Now, if you're not an employee and you're a contractor or a 1099, or if you do not have a written agreement with the company, then the default is that you own that. The inventor, the creator owns that. So it can create a lot of complications and problems, especially when you deal with co-founders or multiple founders, because sometimes those founders are not employees of companies. And so the default rule on employee-employer relationship may not apply. The easiest and most cost-effective way, even though it may not seem like it when you're early on in a startup, is to get things in writing. Hire an attorney, get things drafted properly, make sure it's clearly spelled out who owns what, who's assigned what, who gets what for their work, whether it's equity, whether it's money, combination of the two. Get that ironed out up front. Budget it into your startup costs because it will save you a lot of time, aggravation, and money. A couple of scenarios that can come up. One is a company goes to a designer or a developer and asks them to do some work for them. They may not even be a co-founder, just some generic work. They do that work and they don't get the proper writing in place. And so by default, that designer developer owns the copyright to what they created. You as the company who hired them have an implied license to use it, but you may not actually own the rights to the entire thing. And that can create a problem if you go out to raise some money or you go to sell your company. You may not be actually selling what you think you own. You may only be selling the right to use it, which is a lot different and can create some real complications, especially as companies grow. Now, a lot of times these things don't come to fruition and don't become an issue. And the majority of time they don't become an issue is because the company doesn't make it. So there's nothing to fight over. But when a company becomes successful, when an idea or an invention becomes successful and there's money to be had there, you can bet that anyone that had their hands on it, that it was involved with it, that touched it, is going to want to come and get their share. And that invariably happens. And that, quite frankly, it doesn't matter if they're family, friends, acquaintances, business relationships, whatever it may be. As soon as money's to be had, people are going to try to get their share of it. And it's understandable. So do the right thing. Get your agreements in place up front. At the very least, get it down in writing, even if you choose to not hire an attorney. But I strongly recommend hire an attorney. You'll end up saving a lot of attorney fees later, because if we have to get into litigation and we have to argue about some oral agreement that was made or a handshake deal, it's going to become a lot more expensive and complicated than if it was spelled out in writing and it's clear on who gets what, who owns what, and how that situation is handled. That is the whole purpose of contracts, whole purpose of getting things in writing. And under intellectual property, it really does make a big difference, because unless explicitly in writing or there's a very, very clear employer-employee relationship, the inventor, the creator, owns their IP. And you want to be careful and be sure on who owns what, and if there's any assignments that need to be done, that they're done properly. So save yourself a lot of agony, a lot of heartache, and we get a lot of calls at our firm that involve these types of situations. And if you spend a few $1,000s up front to get things done the right way, you wouldn't be making that call with the uncertainty. It would be a call that says, we have a clear violation of an agreement and we want it to enforce it. That's a much easier and more straightforward scenario than if it's we had a verbal agreement that I would create this and I would own part of this company, and now my co-founder or co-founders took it and went and started a new entity and they're using it and it's mine. We're in a bunch of he said, she said world, and that becomes very messy. And when it's messy, it becomes expensive. So please heed the advice. Do things the right way up front. You'll save a lot in the long run. And I appreciate your time, and any questions, you feel free to reach out to me or anyone at our firm. We'd be happy to answer anything for you. Thank you.